Hello, and welcome to the Duane Morris Money and Banking Law Podcast with Joe Sylvia, brought to you by the global law firm of Duane Morris. I'm your host, Joe Sylvia. I'm a former Federal Reserve lawyer who represents banks, fintechs, and other clients on M&A, payments, and regulatory matters at Duane Morris. I'm also a core member of our banking, fintech, and digital assets and blockchain practices. The goal of the Money and Banking Law Podcast is to inform and educate our clients and friends on both the fundamental concepts and structure of the banking ecosystem, as well as critical developments in the law and regulation of money and banking. On this episode, we're talking about FIRREA and DOJ actions against financial institutions with Chris Casey, who's a partner at Duane Morris in our Philadelphia office. Welcome, Chris. So grateful for your time and for you being here. I'd love to start by asking
Thank you, Joe.
if you could give, I'd like to start by asking if you could give a brief introduction for our audience to learn a little bit about your background and your practice here at Duane Morris.
Sure. And it's great to be with you, Joe, and with the audience. I have been at Duane Morris about 8 years. Before that, I was at the Department of Justice in Washington in the Associate Attorney General's office, and that's some of that work is the subject of what we'll be talking about. I spent a total of about 20 years of my career in various government enforcement roles. Prior to being at Main Justice, I was an assistant United States attorney for about 7 years, and I also spent about 6 years at the Federal Trade Commission, where I did antitrust work. My work has, both on the private side and the public side, has focused on government-facing actions on the defense side and government enforcement on the public side, all revolving around criminal and sometimes quasi-criminal civil actions, where the focus is on fraud. And the main substantive area of my practice on the civil side has been antitrust law.
Fantastic. That's great. I appreciate that. I actually hadn't realized that you were in public service for so long, so I appreciate that. Can you tell us about some of the cases that you worked on while you were a Deputy Associate Attorney General at the DOJ?
Sure. So the Associate Attorney General is the number 3 official at the Department of Justice, and traditionally has handled the civil side of the house, if you will. The Deputy Attorney General, which is the number 2 official, handles criminal matters. So during my time there, I advised the Associate Attorney General on various forms of civil litigation. I was one of about a half dozen deputies, and the deputies all have fairly broad areas of focus and supervision. Mine were antitrust, where I supervised the antitrust division, the United States Trustee Program, which is the United States bankruptcy arm, if you will, and also financial fraud. Another deputy and I were the lead deputies on the cases that the DOJ brought against the largest financial institutions in the country in the wake of the financial crisis. And these were the cases that were brought under the FIRREA statute that you mentioned earlier. It's a civil statute, and we brought a number of actions against the major financial institutions, and the DOJ recovered upwards of $20 million or more, billion with a B, $20 billion or more in financial penalties against the banks for violations of FIRREA. And so it's a very powerful tool the government used in those days. Since then, there has not been as much use of FIRREA by the DOJ. And it'll be interesting to see whether there's, a period when they begin to use it again. I would suspect that there will be, since it's such a powerful tool and since they recovered, many billions of dollars in those cases. But the cases were basically fraudulent theory that the banks engaged in fraud in the securitization and packaging of residential mortgage-backed securities. The beauty of FIRREA for the government is that it's a civil standard, not a criminal standard. And so the government only had to prove those cases by a preponderance of the evidence rather than the criminal standard of beyond a reasonable doubt. And so it served as a useful proxy, if you will, to bringing criminal cases, which, as you know, are difficult to make in financial against financial institutions. We heard a lot in those days, of course, about the fact that nobody went to jail and all of that. Those cases were analyzed criminally. Ultimately, the government, the DOJ, decided to go civilly with cases against the banks, and it was very successful. So that's pretty much a summary of what I did at the DOJ. The other parts of my portfolio, if you will, involved supervising the different components of the department in their dealings with the Associate Attorney General. And as I mentioned, the two components that I focused on were the Antitrust Division and the United States Trustee Program. But I would say probably 75% of my time was in the financial fraud area.
Oh, that's great. I appreciate that. Yeah, no, I was also appreciative of you sharing before we jumped on here an article that you had written back in 2018 for the Banking Law Journal, talking about FIRREA and how it was a powerful tool for the government. And you outlined a few of the things that you just went through. And one of the other things that I thought was interesting was that the statute of limitations period is double that you have for a criminal prosecution. So it's 10 years as opposed to 5 years under the FIRREA statute. So that
Correct.
plus everything that you outlined in that article and what you've just reviewed, it's really does seem to be a powerful statute. I know you talked about the large settlements that you had in the past, and you briefly touched on this, but do you see that it's possible we'll see more FIRREA actions again, like we did when you were at DOJ? Is there any insight that you can provide on what that may or may not look like in the future?
Well, I think, as I said, it's such a powerful tool, and normally when the government has a tool like that, it tends to use it. Now, FIRREA was passed in the early 90s in the wake of the savings and loan scandal, and after it was passed in the 90s and was used back then, it kind of lay dormant for a long time, for several decades, really, until I would say maybe 2011, 12, around that period of time when DOJ began to use it in these bank cases. And I will say it was not without some controversy. The banks had some legitimate concerns about the fact that the FIRREA statute, in their view, was in some of the banks' view was being misused, in the sense that the statute was passed to protect banks, and yet the government was using it against, offensively against banks. And they brought several lawsuits making those arguments. The courts generally upheld the government's use of the statute and the way that the DOJ was using it, but it was controversial in that aspect. The other controversial aspect of it was that in those settlements, the DOJ tacked on to the FIRREA penalty, which was just a straight penalty against the banks. tacked onto that a component of the settlement agreement called consumer relief. And the consumer relief provisions were a, a, really a hodgepodge of different types of reform efforts that the banks had to engage in as part of the settlement agreement to reform individual homeowners' mortgage loans, and to do community outreach and community and consumer type obligations of the banks. And those settlements generally were typically five years. So during the course of that 5 years, the banks had to comply with those consumer relief provisions. When President Trump was elected in 2016, his Attorney General was Jeff Sessions. Jeff Sessions rolled back all of those consumer relief provisions and basically said the policy of the Department of Justice is that we will not be doing these types of settlements that have those types of consumer relief provisions. Some of it was controversial because of the banks were required to provide financial support for different groups that became a political hot button, and but basically, consumer relief went away. There were legacy cases that the Trump administration resolved against the banks, and those took a couple of years to wind their way through. But since then, we've not seen, at least I've not seen, evidence in the press of investigations involving financial institutions where there are similar allegations of fraudulent activity that may be going on. To date, I don't know of any such FIRREA cases that are in the investigative stages. But at least I think with the Trump administration, and for the next several years, I think it's unlikely you'll see these and a resurgence of FIRREA for the reasons that I mentioned, and the controversies that came along with the use of it back then. But these things, as we had the savings and loan scandal, and then we had the financial crisis, and these things tend to come back. Hopefully, not to the same degree, but we may see activity that will get the attention of the government, and they may start using the statute again. I would not be at all surprised, because as I mentioned earlier, the difficulty, and I was a criminal prosecutor for 7 years, proving criminal intent, basically means that you have to crawl into the mind of the people at these institutions and determine what their intent was. Very difficult to prove unless you have direct evidence of it. And so making a criminal case against any large institution, including banks, is very difficult because the responsibilities tend to be diffuse, and you really, in most cases, don't have solid evidence of fraud. So a civil approach can be much more effective. And so for that reason, I think, we will see cases in the future. When that'll happen, I don't know. I think you really would have to see some sort of systemic fraud or other illegal conduct with what the government would perceive as illegal conduct in order to see a resurgence as we saw in the last iteration of FIRREA cases.
Yeah, so let's fast forward a little bit from the previous FIRREA cases to the last few years and maybe broaden the scope. What have you seen from the DOJ in terms of guidance regarding corporate compliance, either specifically under FIRREA or more broadly?
Yeah, so the DOJ has been very forward-leaning, I would say, in the last decade or so in encouraging compliance by companies and encouraging companies to come forward and essentially build or help the government build cases if there's misconduct occurring at the companies. And so there are a number of initiatives that they've come up with. There's voluntary disclosure provisions now where if an institution, a company, comes forward and discloses misconduct at an early enough point, and tells the government all the facts that they know about the misconduct, the government can give that company a declination from prosecution under certain circumstances. In other words, an agreement not to prosecute, or they can these voluntary disclosure programs provide for certain benefits for companies that do that, even if they are charged and there is a case. The fine can be reduced and other things can be done to benefit the company. So there's been a lot of efforts in that regard. There's also been whistleblower programs that have come up. The DOJ Criminal Division had a pilot whistleblower program that they began in 2023, again, to encourage whistleblowers to come forward and report misconduct if it's occurring. And interestingly, the antitrust division, which, as I said before, I supervised when I was at DOJ, recently came up with their own whistleblower program, which was quite a departure for the antitrust division because, as you probably know, that the antitrust division has had for many years a leniency program where the first company to come in and report on cartel activity gets a free pass from any prosecution, and that's been a very successful program. Not been used as much and as aggressively in the past several years as it had in the past, but they've added this whistleblower program because I think they really want to encourage folks to come forward and report misconduct to them. So there's been a lot of activity in that regard, and it presents some unique issues when misconduct is found, and the question is whether to go in and report it. Despite all the benefits the DOJ is offering, there's a decision that has to be made, and often a difficult one. Will the government find this information on their own if you don't tell them about it? That's one issue. Are the benefits you're going to get worth the investigation that's going to ensue? All of those kinds of determinations have to be made. But I think it's clear that the DOJ is looking for white-collar criminal cases to make, and they want companies to come forward and help them to start those cases off. So we're going to see a lot more of that as the years unfold.
Interesting. So, on that note, in light of these updates, what or how can financial institutions improve their compliance programs to be ready for something like that?
Well, I think the best thing to do is what I'm doing right now for a client is to go through the DOJ's compliance guidance, which started in 2017 and has been updated several times since then. There is a document called the Evaluation of Corporate Compliance Programs by the Department of Justice Criminal Division. And it lays out all of the criteria that they look at when they're determining how a company is going to be treated if they come under an investigation. And it's basically a series of guideposts that companies can use to determine, whether the compliance program is good and whether it needs to be improved some. I would also say that one of the things that DOJ has repeatedly said is compliance programs can't just sit on a shelf and collect dust. They've got to be active programs. You need to be reviewing them at least once a year to determine whether they're up to date. so many things are happening now with AI, with with the ephemeral messaging apps where the messages disappear. Those kinds of things are of great concern to the DOJ. And so companies have to be very agile and fast moving in terms of making sure their compliance programs stay up to the current technology and is on top of current technology, because there's so many challenges and risks that come with these new technologies. And the DOJ is very concerned about having access to data and information when they begin an investigation. And things like ephemeral messaging apps make it difficult because those messages disappear, of course. So um, those are things I would, suggest to any company, which is, look at your compliance program, get an analysis of how it compares to DOJ's requirements, and make sure that you're updating it regularly and staying current with all the latest technological changes and the expectations of the government that go along with that.
Yeah, absolutely. That's quite a challenge, but certainly something important to keep mindful of. And I always go back and on my kind of regulatory compliance soapbox and go back to Ben Franklin's famous quote that an ounce of prevention is worth a pound of cure.
Sure, exactly. Yeah.
So, final question for you. Thanks so much for your time. Where can our audience find you if they have any questions or they need your expertise or they need help with their own compliance programs?
So yeah, I'm on the Duane Morris website, and they can find my bio there. I'm also on LinkedIn, and I post things fairly regularly, client alerts and those kinds of things. So they can find me on LinkedIn.
Awesome. Great. Well, thank you again, Chris, for your time and your expertise. We really appreciate you, and I appreciate having you as a partner, especially with your expertise and your experience. Um,
Thank you, Joe. I appreciate you as well.
of course, of course. So if you have any questions from any of our episodes, please reach out to me at jsylvia@duanemorris.com, or you can reach out to Chris or any other of your favorite Duane Morris lawyers. Finally, in closing, please be sure to like and subscribe wherever you get your podcasts. Thanks for listening in. Stay tuned for new episodes coming soon, wherever you do get your podcasts. Thanks.